Hello, and welcome back to Harassment Prevention Training Part 2. Hey, hi Brad, nice to see you again. Thanks for keeping us on track. Let's go ahead and talk about the topics. You have sexual harassment, bullying, and conduct. Sexual harassment. Let's define it. It is unlawful to harass a person, an applicant or employee because of that person's sex. Harassment can include sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Harassment does not have to be of a sexual nature, however, and can include offensive remarks about a person's sex. For example, it is illegal to harass a woman by making offensive comments about women in general. Both the victim and the harasser can either be a woman or a man, and the victim and harasser can be the same sex. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision. So, when it results in an adverse employment decision, such as the victim being fired or demoted, the harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not an employee of the employer, such as a client or customer. Sexual harassment quid pro quo. There's an old saying, don't get your honey from where you butter your bread. Think about that one. So it violates Title VII of the Civil Rights Act and individual state laws. Check your state law. And it states that unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitute sexual harassment when a manager who wants an employee to show them special attention of a sexual nature and they repay them with some type of employment benefit. So this is typically going to be someone who's in a role of influence. Hostile work environment. Now this is a second type of harassment. Anyone can create a hostile work environment. A manager, a non-manager, a customer, a vendor, coworker. However, in the previous example with quid pro quo, only someone with authority or influence can actually create a quid pro quo situation. But for hostile work environment, it could be anyone at work or a vendor. And basically, it's the conduct of another has a goal or effect of interfering with the individual's work performance or creating an intimidating, hostile, or offensive working environment. Retaliation. It is unlawful to retaliate against someone who takes a stand against employment practices that are alleged as discrimination or harassment. They file a complaint for discrimination or harassment, and also if they testify or participate in investigations, proceedings, or litigation. So just put it this way, if an employee expresses a concern, they shouldn't be punished for expressing it. Retaliation is the most frequently alleged basis of discrimination in the federal sector and the most common discrimination finding in the federal sector. Here are some examples of retaliation: termination, demotion, extra work, extra overtime, denial of vacation, freezing out an employee, enforcing policies that were not enforced before. There is employer liability. So, as an employer, the employer has a duty to protect employees from unlawful harassment. This includes harassment by anyone who comes in contact with employees. And the scope of responsibility for that employer is basically the supervisors and managers, the non-managers, the co-workers, customers, vendors, non-employees. Locations, there is no limit if business or work is involved. So any place where work is conducted. Could be lunchrooms, break rooms, on-premise, off-premise, private events, anywhere. Harassment. These are tons of characteristics that could be considered harassment if those reasons are used as a basis of the harassment. Review the list, make a note of it. Let's just pull a few out. Sex, sexual orientation, gender, color, military and veteran status, genetic information, marital status. Also, in California, they specifically have a law against gender identity and gender expression as a level of protection, and also employees can't be discriminated or harassed based on political affiliation or engaging in protected activity. In a nutshell, base all employment decisions and actions and workplace interactions on the knowledge, skills, and abilities of the applicant or employee, not on any of these personal attributes or protected classes. Let's talk about abusive conduct next. Individual states have laws, specifically California has this law. So this is also known as bullying. Abusive conduct means conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. A single act shall not constitute abusive conduct unless it is especially severe and egregious. So typically it's going to be multiple acts. Brad says, thank you for hanging in there. See you in the next module.